This meeting is now being recorded.
Hi, this is Kimberly Simmons, the Executive Director of the Public Defense Commission, here to talk to you about contracting with defending attorneys. Our purpose here is to educate and to be a resource on the contracts that counties will create for their indigent defense services. Contracts were added to the statute as a way of providing indigent defense services in just a few years ago. I mean, specifically as a way for counties to provide services. But how did we get to where we are today? The state of Idaho delegated public defense to the counties in 1897. In 1967, the state finally enacted part of what is now the Idaho Public Defense Act, where they provided specific guidance to the counties on how they can provide those services. At that time, the statute said counties could establish an office of a public defender, or they could arrange with their courts to have an appointed counsel system, or they could do a combination of the above. There has never been any state involvement in indigent defense until recently. In 2014, House Bill 542 was proposed. This is what created the Public Defense Commission. And at the time, it gave us only a few parts of authority and duties. We were to create rules on training and continuing legal education for public defenders, and we were to collect data, including caseload, workload, and indigent defense expenditures. The other part of our duties were to make recommendations to the legislature regarding public defense issues. We could do it on several different public defense issues, but the legislature delineated some specifically, and one of those was core contract requirements, qualification standards for public defenders, and enforcement mechanisms of standards and funding. This statute also did a few other things, this bill did a few other things. It actually removed the appointed counsel system. And so when a judge would just assign a private attorney from the bench to provide public defense services, that's what you call an appointed counsel system, and that was actually removed from the statute. It prohibited fixed fee contracts for services and expenses of a defending attorney, while at the same time adding that counties, in addition to establishing an office of a public defender, could contract with either another office of public defender or with a private attorney or law firm for indigent defense services. So even though some counties were already providing services through contracts, it specifically put that provision into the statute to allow counties to contract for services, while also saying you could not do contracts that were fixed fees for services and expenses. It added the option, I think I mentioned this, of contracting with another county for provision of public defense, and this is another county's public defender office. The institutional public defender in the prior statute was given a 2-year minimum term. That minimum term was removed. And then it eliminated a provision that specifically allowed private practice for those institutional public defenders. It did not add a provision prohibiting it, but there used to be a provision that said institutional public defenders could also carry private cases. That portion of the statute was eliminated. That bill became effective July 1st, 2014, and thus was born the Public Defense Commission. And what happened after that to get us to where we are? In June of 2015, the ACLU filed a class action lawsuit for injunctive relief, and they filed that in Ada County District Court. In the fall of 2015, most likely because of the lawsuit, but also because I think they didn't feel like they had finished their work, the Legislative Public Defense Reform Interim Committee reconvened. And out of those meetings of the Public Defense Reform Interim Committee was born House Bill 504, which was introduced in 2016. Now, many of you have seen the handout, and I'm going to share that on your screen if you'll just give me a moment here. You should see that now. If it's small on your screen, there should be a way that you can make it bigger. But this, I just wanted to show you this. It's available, I think it's on our website. If you can't find it on our website, just ask. But this just shows the differences between House Bill 542 and House Bill 504. And I've been through sort of the differences specifically over the years in several presentations. So I'm not going to do that today, but I did just want to show you that our duties grew enormously in that bill. And it also gave us the authority and mandate to promulgate rules related to model contracts and core requirements for those contracts. All right, I'm going to switch back over to the PowerPoint. Okay. So after that bill was introduced, the ACLU lawsuit was kind of continuing in the background. It was initially dismissed in 2016 of January by Judge Hoagland in Ada County. ACLU did appeal that to the Supreme Court, and recently it was reversed and remanded, meaning the Supreme Court disagreed with Judge Hoagland's decision. They remanded it, meaning sent it back to the district court. That case is ongoing now and is scheduled for trial in September of 2018. So House Bill 504 enacted the current version of Idaho Code Section 19859, which is what tells the counties from the state how they can provide or how they shall provide indigent defense services. As before, you can establish and maintain an office of a public defender. Counties may join with a board of county commissioners of one or more counties within their same judicial district to establish and maintain an office. Minidoka and Cascia have done so for years, and just recently Power and Oneida have joined together to provide their services. Counties may contract with an existing office of public defender. For instance, Clark County could contract with Bonneville County and have Bonneville County provide their indigent defense services. That is different than joining together. And today the subject of our presentation is number 4, contracting with a defending attorney. We're contracting with a law firm or a private attorney to provide services. And as you'll see, this is the provision that also states that there cannot be a single fixed fee for the services and expenses of the attorney. I can't speak to the legislative intent behind this statute. I do believe that ACLU, for instance, would view this statute as meaning no fixed fees at all, so no flat fees for anything. However, because the conjunction says and, it has been read to say that the flat fee just can't be the services and the expenses of the attorney, that the flat fee could be for just the services of the attorney. So the history of Idaho public defense contracts. In 2007, the state appellate public defender had approached the ICJC about conducting a study of the indigent defense delivery system. And out of that bore the NLADA report, which many of us are familiar with. This report talked about those flat fee contracts that have now been banned. And they stated that these contracts created a direct financial conflict of interest between the attorney and the client. Because the attorney is paid the same regardless of whether the case is pled out or whether it goes to trial. And so it can be viewed that, attorneys may have a conflict of interest in that they wouldn't want to drag a case on if they're still going to get paid the same amount of money if the case is pled out. So the interim committee discussed contracts, and they discussed this at length. Their minutes and information about their discussions are available on the legislative website. We also have them here in the office. So specifically in 2014, when the Public Defense Commission was initially created, they talked about the deficient and effective terms in contracts for indigent defense services. And we'll go over those here in a moment. That interim committee also identified core contract terms, and they said that this would be a priority for the newly formed Public Defense Commission, and they talked about that in the fall of 2014. And the Public Defense Commission in the summer of 2015 finalized and created a document called Suggested Model Contract Terms, and I'm going to go through that document today. That document is a little old, as you can tell. We're already 2 years old, and because we have created some standards since the creation of this document, I would expect to see a revised version of this document in the near future. I've already been making some edits, but the Commission needs to review those things first, and so I won't go over what some of those changes might be. I won't speculate, but I can tell you that as we talk about some of these terms, I'll tell you, well, we've created standards that are related to these terms, and so this part will be edited to reflect the standards that we've created. But I do still think that this document is very relevant and has some very good suggestions on how to, or what kinds of terms, to place into your indigent defense services contract. And then you'll also see in the near future a rule regarding the contract. Like what are the core requirements for these contracts? What should they look like? We've been mandated to create that rule under that section you see there in the PowerPoint. And so you'll see that in the future as well. So why is this even important that we're talking about this today? Everything in the suggested model contract terms is based on best practices. They scoured national resources, other states, and what they've done. Oregon has a very nice model contract. There are several states that have sort of suggested model contract terms, some states that have model contracts themselves, and they reviewed all of those when putting together the suggested model contract terms for Idaho. They also adhere to the Sixth Amendment requirements, and so they're very protective, of the Sixth Amendment in ensuring that the services that are provided are constitutional and meet those constitutional requirements. They adhere to principles of an indigent defense delivery system. I see now that those words are reversed in my PowerPoint. I apologize for that. But the terms will comply with these principles, and so they are good to have in your contract to make sure that the services being provided by your attorneys are effective and efficient. They'll protect the counties, they'll protect the defending attorneys, and most importantly, they protect our indigent citizens in Idaho, so the defendants. They also reflect a nationwide perception change regarding the role of defense counsel. Some of the deficient terms or deficient characteristics of contract systems. One is that cost containment is prioritized over quality. It sort of refers to those flat fee contracts for everything and not focusing on the quality of the services provided. It incentivizes pleading cases rather than going to trial. That lawyers who have fewer qualifications or experience, less training, end up doing a greater percentage of the work, maybe because their services are cheaper or less expensive. They offer limited training, supervision, or continuing legal education to new attorneys. They reward low bids rather than realistic bids. The caseload limits are unrealistic, or there are just no limits at all in the contract. There's nothing mentioned about support staff, investigation, or expert services in the contract. They don't provide for independent monitoring or evaluation of performance outside of the cost per case. They don't include case tracking or case management systems as being a requirement. Defending attorneys should be tracking their cases and tracking their expenses to be providing the most effective services. And it's sufficient if those contract systems don't include some sort of requirement or guidance for that. And they don't include a strategy for case weighting. Effective contract systems have the following characteristics. They include minimum attorney qualifications, especially for different case types. They provide support costs, or they provide a way for these costs to be paid for support such as paralegals, investigators, social workers, administrative assistants. Provides independent oversight and monitoring. One of the principles included in our statute is that public defense services are provided independently of political and judicial influence. And so that should be incorporated into a contract system. They should include workload limits. Should include limitation on the practice of law outside the contract. Although this can also be addressed in workload limits. Provides for a way for cases to be completed if the contract ends or if the contract is breached or not renewed. So what are going to happen to cases that the attorney is not quite finished or completed when the contract ends or if the contract is breached by one party or another? Apologize, I noticed that it stopped sharing the PowerPoint. I think we're back on now. Case management and tracking requirements are included in an effective contract. And it includes guidelines on contacting clients, as well as guidelines for the notification of appointment. Attorneys should be notified in a very reasonable and timely manner that they've been appointed so that they can visit with their clients and begin providing services. The contract system should also have a mechanism for evaluation of the services of the defending attorney. So the very basics of contracting, I think this might be very basic for many of you, but the purpose of this webinar is to give you full information and complete information. And so I'm going to start with the basics, and then we'll jump into the suggested model contract terms that the Commission has created as good recommendations and suggestions for you. So the contract should include your parties. So who are the parties? Who's providing the services and who's paying for those services? The scope of the contract. We'll talk about this in a little bit more depth in a minute. But what kinds of cases would your defending attorney be handling under this contract? The term of the contract. When does it start and when does it end? Does it renew automatically? Is there some way that the attorney has to let the county know he wants to renew? One of the suggestions from the National Legal Aid and Defender Association is that multi-year contracts provide some security for both the county and the attorney providing services. And it also, it limits the amount of negotiation that has to occur. It doesn't have, if it's a multi-year contract, you don't have to negotiate every year for the contract. But it also services the goals of independence and security. So that's just something to keep in mind. There has not been any official recommendation from the Commission on that, but I did just want to mention that as we talk about the terms. Is the attorney going to have staff under this contract, or is there a provision on how they provide that staff and how they get paid? And the same for support staff, investigators, or forensic experts. Should have a compensation in there. How much is the attorney going to get paid? Is it hourly? Is it per case? Excuse me. And then you should also have a term for extraordinary compensation. For those cases that are complex, may take longer than the normal average case of that particular type. How is that going to be handled? The compensation of additional attorneys, or how conflict attorneys are going to be compensated. Attorneys should have insurance, and that's something that should be addressed in the contract. And the management system. Is the county going to require a specific case management system, or allow the attorney to choose? Are they going to regulate, what kinds of things that management system has to track? And, of course, our suggestion would be for the requirement to be that the management system tracks what the Public Defense Commission is going to be tracking, and you'll see those in our standards and rules as we move forward. Now we'll talk about the suggested model contract terms. I labeled this like core contract terms because each of the terms we talk about today are pretty essential to a contract for public defense services. And that's certainly the view of the Commission. That's why they put this document together. Follows all the principles that we've talked about, and they also sort of follow along with the standards that we have created and are creating. These are the different areas that should be in your contract. We'll click through them because we'll go through each of these on a separate slide. But you've got to make sure you have the scope of the contract, the reports and inspections that the attorneys or the contractee must fulfill, how they must establish and maintain their records and files, performance, training, and experience requirements of the defending attorney. So these are going to be the list of case types that your county should be considering for indigent defense services. Now, depending on the size of your county, you may have one attorney providing all of these services or handling all of these case types, or you may break it down between some attorneys. Some counties have attorneys that handle the felonies, and then the other attorneys that handle misdemeanors, and then maybe other attorneys that handle juvenile or child protection. So you should certainly have a provision for capital cases, felony cases that are not capital cases. And capital cases, if you're not familiar, are those that where the death penalty could be imposed. Misdemeanor cases, who's handling probation violation or revocations, and who's going to handle contempt. When I say contempt in this realm, I'm talking about a criminal contempt. And for those that aren't familiar, if someone is, let's say they're convicted of a misdemeanor, but they're not placed on probation, but the judge says, you must pay a fine and go get an evaluation. Well, since that person's not on probation, they can't get a probation violation if they go get their evaluation. But the evaluation was a court order, and for them to not get the evaluation is considered a contempt of court. And so that's the kind of contempt I'm talking about here. Should cover appeals from magistrate to district court. This would be appeals in misdemeanor cases. Those are appeals that are never handled by the state appellate public defender. Juvenile cases, involuntary mental health commitment, post-conviction relief, child protection or parent representation cases, termination of parental rights, including the appeals of PPRs, criminal contempt arising from a civil case. If the court has ordered someone to pay child support and they don't pay their child support, that could be a criminal contempt charge. Court-initiated contempt. This is getting sort of into the nitty-gritty of contempt, and I won't describe it too much, but they are definitely different than the other kinds of contempt. And because sometimes these are called civil contempt, if your contract specifically says your attorney's handling criminal contempt, then that attorney may not be responsible for handling the court-initiated contempt or even this contempt pursuant to Idaho Rule of Civil Procedure Rule 75. And so you want to make sure you're considering these in your contracts and that you have an attorney that will handle those. Extradition, if another state is seeking a defendant that is here in Idaho. Make sure you have a provision for those. Misdemeanor appeals, we sort of covered that in the appeals from magistrate to district court, but delinquency appeals, those would be juvenile appeals. Again, those are not handled by the state appellate public defenders. And then a provision for felony appeals in the event that the county doesn't participate in capital crimes defense funds. Because if a county doesn't participate in that, then they don't get the services of the state appellate public defender. So in that case, the attorneys in that county would have to handle the felony appeals as well. And I do think I should mention here, it is possible for a defending attorney to not ask for the state defender to be appointed on a felony appeal. It's happened a few times in some counties, and then the defending attorney in that county handled that. And so you might want to either talk to your defending attorneys about that, if you want them or not wanting to do that, but they should be compensated if they are handling those felony appeals. And then you want to make sure that you're also addressing problem-solving courts if you have those in your area, and they can be broken down by type. The drug court, the mental health court, veterans court, DUI court, domestic violence court. And then post-judgment motions. Who are going to handle those? Are those going to be handled by your primary attorney? I mean, these are very simple, basic motions. I would always say just include these with all of your, in all your contracts. You know, an attorney should really handle post-judgment motions of a case that they've already handled. Reports and inspections. This section, the county should request that the defending attorney provide the following reports at certain times. And the Public Defense Commission recommends that counties ask for an employee profile. So who are the attorneys that are under this contract? Is it just the primary attorney that signed the contract, or are there other attorneys in the office? Are there legal and support staff who perform work under the contract? I think it's important for the county to know who's being compensated and working under the contract. Education and training. The Public Defense Commission recommends a term where the defending attorney would submit to the county their continuing legal education credits and any other training that's related to the case types that they handle, and that they report those to the county. And this is something, the education and training is also something that we will be requiring, or we do require in our annual reports of defending attorneys. And so when they submit those annual reports, it should have that in there. And so it's good to have it in your contract, but you should be getting that as part of the annual report. Caseload report. Defending attorneys should submit to the county the number of cases that they completed in the past year that they handled, and list them by case type. Again, that is something that is going to be requested of the attorneys in those annual reports, so you should be getting those as well. We also recommend that attorneys submit expenditure reports for any expenses that are non-personnel. So if there were expenses for investigation, witnesses, experts, travel, anything that's not salary per se should be reported to the county. This way the county knows how much their indigent defense services are costing. The attorney should report to the county if they've used any subcontract attorneys and who those attorneys have been, or if they've conflicted cases to any attorneys, so the county knows who are handling cases in their county. The county should require defending attorneys to report to them any disciplinary actions taken by the Idaho State Bar. Defending attorneys should agree to grant the county access to materials to verify compliance with terms of the contract. The term should also address that these inspections that are required won't violate any attorney-client privileged documentation or anything that's supposed to remain confidential. in that the attorney should only provide information in these inspections that will protect their clients. But the county should be able to make sure and ensure that defending attorneys are following the terms of their contract. The county should also include reporting requirements for defending attorney contracts. Now, this is one provision of this document that I can suggest may change. Specifically, right now, it states that the defending attorney should comply with Idaho Code 19-864, which is the statutory section that requires defending attorneys to submit annual reports. And in this document, it talks about what should be included in those annual reports, number of persons represented, the crimes involved, or the nature of the appointment, expenditures by category, for example, investigations, evaluations, travel, and number 4 is number of cases requiring appointment of conflict attorneys. This will the reason why this will change is because we've created an annual reporting form that asks for these things plus more stuff, other things. And so we would just recommend that the contracts say that the defending attorney comply with Idaho Code 19-864 and Public Defense Commission Indigent Defense Standards, because that will be something that we do require. And that just makes it a little easier for you to not have to continue. If you list out everything specifically and then we ask for more, then your contract doesn't match our standards. So if you just say follow our standards, it's a little bit easier. The next term that should be included in your contract is establishment and maintenance of records. This is just a suggestion that the defending attorney agree to maintain accounts and records regarding personnel, property, financial and programmatic records to reflect direct and indirect costs of services performed under the contract. Also maintaining accounts and records reflecting these costs as to subcontracts or other personal service contracts for which they've engaged in under the contract. The next term that should be included in your contracts are performance requirements. Now, in the document that the Public Defense created, they do talk about the ADA 10 principles of a public defense delivery system. And while I do think that those are should be followed, Idaho has adopted, since the creation of this document, Idaho has adopted their own 10 principles that are in the statute, and that has also been promulgated into a rule. And they're based on the ADA principles, but they're slightly different. So be familiar with those, and maybe mention the Idaho principles of an indigent defense delivery system in your contract. Also talks about the performance guidelines of the National Legal Aid and Defender Association. Being familiar with those and placing that term in your contracts also recommended. Under the performance requirements, the terms that are suggested are the following. One is continuity of representation at all stages of a case, sometimes referred to as vertical representation. You'll see here this is already required by indigent defense standards. That was a rule that was created in 2016 that became effective on May 1st of 2017. And as a reminder, must be complied with by March 31st of 2018. Another term that should be included is that a defending attorney should contact their clients upon assignment. And you could even be more specific in your contract. You can give a timeline. The suggestion in the document is within 5 working days from notification of case assignment. I think some counties have within 48 hours. I think the sooner the better, but we certainly understand the practical requirements when an attorney might live outside of the county. And so I think I would negotiate that with your defending attorney. What's reasonable, but what's quick so that the client can get the services that they have been given and that you meet constitutional requirements. Should have a provision regarding conflicts of interest. They can be numerous sometimes, but you should have a provision that the defending attorney will agree to screen all cases for conflict upon assignment and as the case proceeds. The defending attorney will refer to the Idaho Rules of Professional Conduct as interpreted by the Idaho State Bar, as interpreted in opinions of the state judiciary, and any other authority available. Should be a term talking about caseload management. Attorneys should manage his or her caseload in accordance with the Idaho Rules of Professional Conduct. There is also some language in the indigent defense standards that were created this past year that reference that caseload management, that an attorney basically should not be handling more cases than they can effectively handle under the Constitution. There should be a provision regarding extraordinary compensation. Now, the document suggests that if a case takes more than 60 hours of an attorney's time, that the attorney be provided with extraordinary compensation. Now, the county is certainly free to put whatever number in that section that they would like. But 60 hours is what has been recommended by the Public Defense Commission. Should be a term that the defending attorney agrees to have an adequate support staff so they can render competent assistance of counsel at the caseload levels that have been described in the contract. There should be a provision regarding complex litigation in capital cases. Is this contract going to cover capital cases, or will there be, or if the attorney is appointed to a capital case, will there be compensation above and beyond the ordinary compensation listed in the contract? The indigent defense standards that are being created for this year that are not in effect yet do reference the use of investigators, that attorneys should be using investigators where they are needed. Not just in complex litigation and not just in capital cases, but it should be considered in the contract in this area. And capital counsel qualifications is also something that is being created right now and will be a topic of conversation at the public hearings in October. So something else to be aware of when addressing this term in your contract. There should be a provision that addresses a significant increase in workload. If all of a sudden there are a ton more cases being filed in your county than usual, how is that going to be handled? We also recommend, though this is not specific in the document, compliance with indigent defense standards. When I use that term indigent defense standards, that is actually a term of art. It is defined in our rules as anything that has been created by the Public Defense Commission under the IDAPA, the administrative rule process. And so I'm being very specific when I say indigent defense standards there, meaning anything that we have created, and that is an IDAPA rule. So compliance with those standards should be in your contract. We do recommend that. And then I also mentioned the ADA guidelines and the NLADA performance guidelines. This contract should also address training requirements. Currently, the indigent defense standards provide that attorneys should get 7 hours of continuing legal education every year in topics related to indigent defense. That's a very wide area. It can be criminal defense, it can be immigration law, juvenile, mental health, jury selection, anything related to trial or litigation. Water law is not one of those. But the Public Defense Commission provides all this training, and so it shouldn't be hard for attorneys to get this. But this should be something that is definitely included in your contract. And I think you can say comply with indigent defense standards as regards to training, or you can be more specific. You're certainly free to recommend that they complete more hours of training. That's up to you. The standards also address specialized cases, and I've listed those out here. In these types of cases, the standards require that attorneys get 3 hours every 2 years if they handle one of these types of cases. So, for instance, if an attorney is going to handle a juvenile case, then they're required to have 3 hours of continuing legal education in juvenile cases every 2 years. Or, if that has not been made available or they don't have time to go get that immediately upon appointment to a juvenile case, they must seek advice of an experienced attorney in that area. And so we know that defending attorneys may have a hard time getting all of this training, and so there is a way for them to continue handling those cases. But that's something that should be included in your contract. And then capital counsel, again, that's a rule that we're creating currently, and so the proposed rule states that capital counsel, anyone handling a capital case, must get 12 hours in capital-related training every 2 years. That is, I believe, the same requirement right now that's required under the Idaho Supreme Court rule to get on the capital counsel roster. So that is the same. And the Public Defense Commission is going to do what they can to provide those resources to attorneys here in Idaho, and if not, to provide scholarships for attorneys to attend those so that they can get that kind of training. But that should definitely be included in your contract, especially if your defending attorney is going to handle capital cases. Experience requirements is another term that should be included in your contract. This is to assure that the indigent receives effective assistance of counsel. And the document that the suggested model core contract terms document goes on for several pages, and it describes the experience required for all of these different types of cases. I'm just going to click through them here. So there are basic requirements, like satisfying minimum requirements for practicing law, which means you should be barred. You should have passed the bar exam. You should have a law degree. You should be familiar with statutes, court rules, constitutional provisions, be familiar with the Idaho rules of professional conduct, those kinds of things, some basic requirements. And then there are some suggestions in our document of what kind of experience different attorneys should have to handle these different types of cases. I would highly suggest that you take a look at those and match them up to the attorneys in your county and include them in your contract terms. Now, the Public Defense Commission is aware that some of these requirements may be hard for the attorneys in your county to meet. If you're having some trouble with those, let's talk to us, work with your regional coordinators on your contracts, and we'll help you develop a term in your contract that can work for your county, but also at the same time be able to ensure that you have a quality attorney providing the services in your county for those specific types of cases. Now, the document goes on to talk about, it has some definitions in there that you should be familiar with, and so you can peruse through those. I'm not going to go through those today in the PowerPoint. And then the document also lists, it also has attached to it the ADA guidelines, the 10 principles of a public defense delivery system, and references the NLADA performance guidelines. And so that's another resource for you. When you're awarding a contract, so when you are seeking out the attorney that you would like to provide your services, the NLADA has a guideline that the contracting authority should award them to those that have complied with the guidelines, and the contract should not be awarded on the basis of cost alone. The contracting authority should determine whether the proposed budget of a potential contractor will provide the capability of complying with these guidelines. Further, the contract should be awarded to someone who meets the rules of the State Public Defense Commission and should avoid awarding the contract to the lowest bidder. Now, if the lowest bidder happens to be the one that was the most qualified, the most appropriately experienced, and satisfies the above, so the NLADA guidelines and meets the rules of the State Public Defense Commission, we're not saying you can't give it to the lowest bidder. but certainly just awarding it to the lowest bidder is probably not the best course of action. Okay, so I'm going to leave this here on your screen for a moment. These are some resources to help you build your contract. Oregon has a model contract that they provide for their agencies. They do services a little different in Oregon. The NLABA does have a model contract, and if you were to take a look at that, you'll notice that there are some very similar provisions in their model contract as are in our suggested terms. The DOJ has a compendium of standards for defense services, and they talk about contracts. And so you can review all these documents. What I will do when I post the recorded webinar today to the website, I will list these resources under it as links, and so you will be able to link directly to it. If you need it now and you don't see the links in the next day or two, you're certainly welcome to shoot me an email and ask me for those. All right. This is a really great time for some questions, if anybody has any. I'm going to switch back to the PowerPoint for a brief moment while you think, if you guys think if you have any questions for me, because I do have one additional slide that I want to show you. That's not necessarily part of the contracting webinar. We do have 2 more educational webinars coming up. One is on October 3rd at 11:30 Mountain Time. In that webinar, it's a 2-part webinar. We'll talk about a new chapter that we're proposing. It's IDAPA 610108. This is just a chapter that incorporates all of the documents that we've referenced in our rules, including the standards for defending attorneys, and it also has all of our definitions in one place. We currently have all our definitions in each chapter that we've created or proposed, and the problem with that is if we change a definition and it's in 2 separate chapters, then we have to go change both chapters, and so we decided that we want to put all the definitions in one place for ease of reference, and end up having to amend any of those definitions. We can do it in one place. And so we'll go over that document. We'll kind of talk about some of the definitions. And then we'll also go over the procedures related to oversight and enforcement of standards, which is our proposed rule 610106. Some of you have seen this. Some of you will participate in the negotiation process. And we'll talk about how the Public Defense Commission sort of sees the oversight process going and the enforcement process going by going through this standard. And my goal here is to sort of talk about what the rule says and what the rule doesn't say. And then the second webinar will be on the standards for defending attorneys. I will briefly go over what has already been created and is currently in effect. And then we'll talk about more, for the bigger part of the webinar, we'll talk about the ones that we're creating for this year, which includes capital counsel standards, investigation standards as well. And then there you'll see on your screen the public hearings that we have on these proposed rules. They're all at 6 p.m. local time, so Lewiston and Coeur d'Alene will be 6 p.m. Pacific. The only one that's not at 6 p.m. is Boise, which will be at 4 p.m. I know. Oh, it is? I was told that the screen is blank. Hopefully you can see it now. So hopefully that's on your screen now. These public hearings are listed on our website as well. The schedule of the webinars are listed on our website as well. I'm going to flip back and make sure that nobody has had. I do have a question. Let me see what that is. So the question that has been asked is regarding flat fee contracts. Is allowing for expert and investigative fees outside the attorney's fees sufficient to meet that prohibition at this time? I believe so. I think the argument can be made based on the way the statute is worded that if there is a flat fee in a contract, that if it's for the services of the attorney only, So if it's, I don't know, $4,000 a month for the attorney's services. But there is also a provision that provides that the attorney may ask the county for funds for an expert and funds for an investigator. If that is separate from that $4,000 a month, then I think there's an argument to be made that that still satisfies the statutory requirement that flat fees not cover both of those things, so that the flat fee doesn't cover the services and the investigation and expert fees. I hope that answers your question. If not, please shoot me a message here. I will say, on flat fee contracts, I can't tell you what the commission is definitely going to do on this, but the ACLU is still challenging any flat fee at all. And so, just so you know, there's a possibility that a court could say that you can't have a flat fee at all. You know, there is an argument, I think, to be made that a flat fee in any way, whether it includes the expenses outside services, can still be a conflict of interest for the attorney. I have read at least one case from another state, it's not Idaho, that has said that that's not an inherent conflict, that there has to be some prejudice shown, or there has to be something that the attorney did to prove that there was a conflict. But that's another state, and I don't know how the courts in Idaho would look on that. But I just wanted to make note that it's still something that the ACLU is pursuing. Okay, well, we did end about a half hour early. I kind of anticipated that, and I'm not going to hold you on for a half hour to continue talking about contracts